Hi, everyone. I am Irina Dashevsky. I am the co-chair of Greenspoon Marder's Cannabis Group. Continuing on with our deep dive into the recent rescheduling order, we wanted to share some more information, given the impending June 26th deadline for people to register with the DEA. So, with me today, I've got Jason Beck, Eric Katz, and Mark Coast. I'm going to let them introduce themselves and explain to you what they do. And from there, I'm sure you'll glean why we're having a conversation with these guys and kind of what next steps are out there with respect to this registration. And once you register, what that could look like. Jason, why don't you kick it off for us?
Thank you so much, Irina. I'm Jason Beck. I am the longest continuous retail operator of cannabis in the United States, and also was a former finance chairman and point person on cannabis policy and messaging for Congressman Rohrabacher, where together we created the Rohrabacher-Farr Amendment, which is the federal appropriations bill that prohibits the DOJ and DEA from extrapolating federal funds to go after state licensed cannabis businesses, which is the single piece of federal legislation that has allowed for the industry to grow into the state that it is today. And through my numerous years in the government affairs space, I recently started Freedom and Technology Consultants. And one of the unique offerings that we offer is to be able to help cannabis companies navigate through the DEA registration application process and ultimately secure their DEA registration under a Schedule 3 guise. And through that process, I have enlisted the assistance of Eric Katz, who will tell you about himself, as well as Mark Coast. And I'll let both of them talk to you and introduce themselves in regards to their area of expertise and backgrounds. Eric?
Thank you, Jason. Good afternoon. My name is Eric Katz, retired DEA Supervisory Special Agent of 25 years, prior state law enforcement experience. Before that, I currently work with a security logistics company of my own, and have worked in numerous positions throughout the DEA in my career, to include regulatory and compliance issues as they relate to the diversion of pharmaceuticals, which is what we're here to talk about today, in particular, the new rescheduling of cannabis. Mark?
Eric.
Oh, thanks for inviting me, Irina, and having us on. I'm Mark Coast. I'm the CEO of Blockchain Agricultural Solutions, Inc. I'm also a retired DEA agent, 23 years on the job, working at the border. I used to work in science and technology. I'm an engineer by trade. I'm also a retired Marine Colonel from the Marine Corps Reserve, and I'm a strategic planner from the Pentagon. And our company has been working on this for a while, and we've been anticipating the rescheduling of cannabis to Schedule 3 for the last couple of years. So we've had the opportunity to get a good jump on the market and look at what's going to happen from 2 years ago to where we think it's going to go based on historical information.
Thanks, Mark. So, I think given your guys' background, it's clear why we have you on and want to have this conversation. What resonated for me as we'd been talking over the past 2 weeks is, Jason, let's start with your perspective, which is that, based on the order, it, one could have a takeaway that registrations, um, and I think, candidly, we maybe even had sort of a wait and see approach. You don't need to be first in line. It's not clear what's going on. There's further hearings coming up. I will acknowledge that medical cannabis, as we sit here today, has been rescheduled to Schedule 3. And, you've told me in the past you don't really think it's optional. So I'd love for you to explain where that's coming from, the basis for that, and, that if it's not optional, folks, we've got about 2 weeks. And so we can then go to Eric and Mark and talk about this application and kind of next steps.
Yes, I do not believe that it is optional at all. I believe that it is a mandate. So when the Attorney General, acting AG Todd Blanche, executed this executive order, he classified all medical cannabis as being under the umbrella of Schedule 3. and said anyone operating under Schedule 3 needs to register with the DEA to obtain a DEA registration number per Schedule 3. Now, there's a number of companies and people that I've talked to throughout the industry that believe that this is a option, or they believe that, medical sales are only a fraction of their sales in regards to the amount of revenues that they do. So therefore, they don't believe that they fall under the medical guise. But however, my interpretation, and I believe is also Eric and Mark's interpretation of how the federal government and mainly the DEA will view this, is the fact that if you are operating within a framework that allows for you to commence in medical commerce and or adult use commerce, that if you are operating with the um, local ordinance allowing you or state ordinance allowing you to commence in medical sales or medical production in any way, regardless of how much of that business that is today, you are operating under a medical guise, and therefore you are required to register under Schedule 3 with the DEA of your cannabis company. And so that is my overall arching basis of why, and I encourage everyone to register before the deadline, because I do believe that the lowest hanging fruit are going to be all of the companies that do not register with the DEA and have some type of framework in place to where they are allowed to commence in medical sales. And I believe that the DEA is going to view that as immediate diversion. Those will be the lowest hanging fruit that they will go after first, in my opinion. And that's kind of where I stand on this issue. So I am encouraging everyone to register with the DEA. It's a fairly simple process. It's not something that is extremely overly complicated. Not to mention, it is the only way that I believe that you are going to be able to maintain operational status throughout this process. I do believe that if the DEA comes in and says, "Hey, how come you haven't registered?" and gives you the ability still to register, you will not be able to maintain operational status throughout that procedure as far as obtaining your DEA registration number, whether they allow you to or not. But nonetheless, they will not allow you to continue in commerce until that registration is issued. And so that can be a very extremely expensive cost for people to continue paying rent on infrastructure and not having any commerce commenced during that time. And we don't know how long this is going to take, whether it's going to take a year, 2 years, 6 months. And so the fees and cost of that could be very burdensome for many companies.
Okay, thanks, Jason. I want to get some clarity on this one piece. You know, Attorney General Blanche issued the order. The order does not say it's mandatory. I've read it many times. So, Eric, could you maybe tell us where you're extrapolating or where, Jason, you are extrapolating that it is mandatory because of all the other sort of rules, regs, and things that apply to now to Schedule 3 narcotics? Is that where this is coming from?
Yes. So it is not it is not mandatory. It is voluntary. If you want to stay in business, if you want to lawfully handle Schedule 3 medical cannabis under federal law, you have to register. They're not forcing you to register, but know that at the expiration date of the 26th, it will become, in my opinion, a binary decision for DEA. The first thing they're going to do is look to see if you are in that database and have registered and have that temporary hall pass expedited registration process underway. If you do, you'll get a pass in that time while they work through that process. If you're not, you are already in violation. And as Jason talked about, this is not a criminal procedure. It's a administrative procedure done by DEA diversion. They are funded entirely by what they call a fee account. So they fund themselves through the fees and penalties they assess on industry. The fees, if you are in violation, are excessive. And, whether your company can withstand those kind of fees, it seems unlikely. They will shut you down.
Wow. Okay, so with that kind of framework, right? I've had some people say, well, look, the app is not that hard, but the questions it's asking are giving me heartburn. They are problematic. And you're familiar with that app, and the questions say things like list every employee, list every vendor, attest to the fact that you essentially out yourself that you have been handling Schedule 1 narcotics in the past. I can't remember exact questioning, but that was the upshot of one of those questions. What do you make of those kinds of questions and, you know, to register or not register against having to deal with those kinds of questions?
Well, in regards to the handling of the Schedule 1, I mean, the DEA knew you were handling Schedule 1 narcotics prior to, to this change in the scheduling. So, and there was never particularly aggressive enforcement activity, but you have to understand that now this is not an enforcement related issue, and you have to stop thinking about things in a prosecutorial mindset. For example, if you make clones and you say, well, those aren't plants because there's no root ball, they're not going to care about that. You are a manufacturer now. This is medicine, and anything the from cultivation, manufacturing, all of those things are all going to fall into if you look at the application process, they all fall into that space. Um, so I think that while I understand your reservations, obviously you've had a prohibition on this substance for an incredibly long period of time, and everybody is particularly uncomfortable and does not trust the government, and I don't blame them. But that being said, not participating, you are opening yourself up to, as Jason said, you will be the low-hanging fruit when it comes to targeting, because they can show up at your business. They don't need a search warrant. This is if you're handling, and it's no different than the company that's making Valium, right? They can show up at your business. If you refuse them, they'll shut you down, right? The fines start on the spot. So I completely understand everybody's reluctance in this area, but at the same time, not doing it will be far worse than just putting your head in the sand and hoping that they don't bother you. Now, along the lines of the application, you should take some care in what you do there, because and how and who, if you have employees that have, when they get around to reviewing these applications, it's the same thing. You have employees that have extensive criminal histories. If you read through the section on the employees and on the their histories, this can become problematic later on as well. I think as they start reviewing these applications, would be no different than how they would view a nurse at a hospital that's handling controlled substances that has multiple drug use arrests or convictions, right? It starts to pose problems there. So take care in the information that's provided in that regard as well.
And also, too, just to opine a little bit on that, I don't think operators should have a hesitancy or a fear around clicking that box of, yes, I've been dealing with a Schedule 1 substance, because the reality of it is this, is that in order to be licensed in all of these different states, all of these operators have had to submit to a live scan background check, which is a full FBI background check, DEA, all these other different government agencies to be cleared in order to have these licenses in the first place. So why there would be a hesitation all of a sudden to fill out a yes on this form, I'm not really understanding that, seeing as how they've already all have gone through a live scan process. And Eric, if you could please elaborate on the fees for what and the penalties that it is for lying on this form.
Right. Well, as I said earlier, I agree with Jason. I think there is no appetite for the prosecution of anybody related to Schedule 1 cannabis, and it would require far more than that. And you willingly submitting information per their request in order to move this process into legitimacy is not the kind of is
I
certainly would
gotcha.
be unwise. Yeah, I mean, come on, like who are they going to prosecute here? And they don't need to if their interest is in raking in fees and bringing this into the legitimate market, there would be that would just cause chaos and wouldn't be well received anywhere, specifically even in this administration. So now the penalties related to failing to comply are massive, and I think Jason has a document where we kind of lay it all out there. But each violation, a single violation of the Controlled Substance Act, can be $25,000, right? And they just stack on top of each other. And then not only that, but depending on what you're doing in this process, the other agencies that they can bring in, the FDA, OSHA. I mean, you will not survive a process where you have just EPA have refused to comply in any way if you fall under this microscope. And you may survive for some time because there is a lot of people in this industry already. But as I said, you're not afforded the protections. You are under a criminal investigation. It's an administrative process, no different than when they've seized currency. You know, your currency has no rights. Okay, this is administrative, so it's the same thing, and you will find how unpleasant it could be, and it's very unlikely you would survive that
So
process.
it's starting to look like it's not such a close call. Register, don't register. I want to kind of, Mark, I want you to weigh in on, okay, folks have registered. What's also unclear from the order is how the interaction with DA and kind of how all of this will go from there. And I understand register one. Can you talk a little bit about like how you think this all plays out and also your company and kind of how it fits within this framework?
Yeah, absolutely. The way I look at it is it's a bit myopic for several of the people because they're more worried about the DEA, what's going to happen at the upfront. What they haven't seen are the different things that are working behind the scenes. I look at it as it's a good process that it's moved to Schedule 3 and the fact that it's moving the industry from black market through gray market to a full white market commodity. And it's just going through the processes right now. And I'll give you an example. So now that we're going to go through Schedule 3, assuming you get your permits, there's all sorts of things that open up for the individuals that hadn't existed previously. So let's assume you get a state and you have a federal permit. You're basically going to be able to function unmolested. You've paid your fine or your fees, I should say, and you're conducting your business and you're going about your business there. What they don't see are all the other stakeholder agencies that are in the industry that are going to be a part of this now. Obviously, the FDA is because now it's a drug. And you're also going to have the IRS because now that you are Schedule 3, you have a legal way to actually deduct your business expenses from your tax return. That's a huge windfall. Anybody gets to deduct tax, anything business expenses, that's a big deal, right? It'll probably offset the cost of your permits. So that's a huge entity. Along with that comes the fact that you're going to be able to run your money through federally regulated banks. You're going to be comporting with anti-money laundering laws and Bank Secrecy Act, which wasn't open to them before. Everything was isolated in a state and they operated like an island. This opens the door. You're going to get to do interstate commerce. You're going to be able to move your products from, as long as they're registrants, from one registrant to another, which you haven't been able to do in the past. So that opens up the door for all sorts of things. As long as you have a traceability system, and that's what my company's been working on for the last several years, is to have a track and trace system, which is required. It's still there, which allows you to monitor the movement because you're handling a controlled substance. So that's why anybody that handles a controlled substance needs to be a registrant. Even if you're a remediation company that has to destroy things that or have been in the past, out there, they had to have it, even if they were destroying things. And I'll give you another example that, most people are unaware of because there's a whole progression moving that they haven't really seen. For example, the National Institute of Standards and Technology, NIST, has a CANA QAP, which is a quality assurance program. I encourage any of these people that are curious to go look that up. And there is a whole process for NIST, which defines how cannabis is going to be tested for heavy metals and pesticides. And so it becomes a safe product. This is not unlike any other products that are out there. They have to go through laboratory analysis. So you're going to get a certificate of analysis that comes with it. So the end users know exactly what they're getting. So our system is set up to monitor all these things. So I look at it as a beneficial opportunity for the environment now that it's moved to Schedule 3 for all the reasons that I've said. One of the biggest things that I think is going to be coming that's beneficial for them, for example, say these big pharmacies across the country, and I'm just throwing names out like CVS, Walgreens, or say Amazon Pharmacy, they have the opportunity to become suppliers for these larger entities as long as they adhere to the new CANA QAP standards and all these different standards that are moving behind the scenes. So the train is moving in one direction. The part about just getting the permit, in my mind, is just a single step to get you on the train that moves this into the white space, which gives you all these other benefits that come with it.
Thank you. That was really kind of like big picture. And Eric, just to drill down a little bit on that, what do you envision? The order kind of said, look, you've got to transact with the DA. You have to have this transaction with them before you can then engage in interstate commerce. At least that's kind of how I read it. They're now part of this transactional. Your interstate commerce transaction is sort of like hinging on, or they're a predicate to that. And I'm just trying to get a little bit of clarity. Do you guys have any sense of what that actually means? Is the DA going to come take possession first, or is it kind of like an exchange of funds? What are we looking at here?
So I can address that. So for example, once you have your DEA permit, right? So you can also sign up for import export permits, right? Those are different. They're like half the price, but it gives you the ability to import and export cannabis as long as it's medicinal. But within the domestic frame, you don't need a special permit to move as long as you already have you're a scheduled registrant, as I mentioned earlier, you're allowed to move the products from one registrant to another without filing special permits. That's never been an option before. Every state has been functioning like an island. This is the first time you're going to see interstate commerce open up, which is, in my mind, that's a good thing for the industry at large because it's going to change the industry on how it moves their products and sales. And like I mentioned before, even for big pharmacies and how they are going to dispense in the future. So, like I said, you can see how the wave is moving in one direction. And I think it's predominantly positive once you get away from the do I have to pay for the permits? Yes,
But
but then that gives you all these other things that come with it.
I hear you. But does any other Schedule 3 registrant have to engage in a transaction with the DA where they quote unquote buy at a nominal price, whatever that means? And what is that? Like, what is that transaction?
I think
Because the way I
I,
looked at it, that was like a treaty requirement. That's how they framed it.
I
And I'm
think
just trying to
Arena.
understand how extensive that is or could be.
I think Arena, just to put it in a layman's terms, I think that that transaction exists similar to like a escrow company with the sale of a house. Yes, the DEA is involved in the transaction. However, them actually coming and picking up the actual quantity, delivering it to the actual buyer or whatnot is not a reality. It's just more like an escrow company in regards to ensure a proper, legitimate transaction.
Got it.
Yeah.
Um,
I mean, there's already Schedule 3 drugs that move, like they go from the manufacturer to
yeah.
pharmacies, and the DEA is not physically involved with any of that process. As long as you track it, you have a track and trace system which tracks it. So as long as they know where it's going, there's not going to be a problem with it. So that's what we've been working on so that it opens the door for them to do these things. And if they want to look at the documents, and so as long as you're you have a space where the track and trace is functioning and you can show where it's going and it's all within the bounds of the law, there's no problem there.
Yeah, it's no
Um,
different than any other Schedule 3 company would be required to. It's the same compliance when it comes to, and as Mark was, Mark was stating about his company, what's key about BCAGs is that it's building a government ready compliance file for you, right? It's mapping inventory from source to disposition, creates audit ready chain of custody records, right? All of these things that you're going to need, identifies diversion vulnerabilities there before a regulator does, so you can show that you're tracking and tracing what you're doing, and yeah, we observed this, we corrected it. These are the things, if you were to be inspected, they expect to see that you know where all of your product is, how it moved, right, and where it ended up, and that everything is in compliance. And that strengthens your company in events, for investors, lenders, banking diligence. These are all key to, as Mark said, being part of the white market.
Also, Eric, it also promotes quality control on the product because Mark's technology also engages in environmental controls to ensure a product's sustainability while it's moving throughout transit. And as cannabis being a plant and something that is constantly degrading over time or decaying over time, keeping it in the most opportune environment throughout its entire process from when it's going from harvest, manufacture, or to the end consumer is really one of the main goals in preserving quality for the end consumer that's going to be purchasing your product. And that's something that Mark's technology will ensure.
One of the things I didn't add, thanks, Jason. And one of the things I was going to add about that is that with the way we have the track and trace system set up, is that because it's patented, so it's regulatory in the fact that commercial and government can use the system. So there's limited view capabilities, but as you're using the system, the government can look at it if they have a question about something, they can look at the data in there which is going to answer their questions without having to interface with the actual clients unless something is completely a mess. But what it will do is allow them to look at it and go, yeah, it moved from point A to B to C. All their questions are answered, which you're not going to you won't have to interface with them nearly as often as you would under the current system where they come out and do physical audits. Not to say that that wouldn't happen, but it should significantly reduce that because the data is out there for them to see. It provides transparency to them, which the government currently does not have.
okay. I want to kind of end with a conversation about adult use. So, as we sit here today, medical cannabis is rescheduled to three. All other cannabis, uh, including adult use, is currently Schedule 1, and I know we're coming upon the hearings in June to consider rescheduling all of cannabis to three. I'd love to hear your guys' thoughts on what happens from the DEA and the DA's perspective if all cannabis is rescheduled to Schedule 3. So then what you'll have is state licensed adult use licensees, not dual use, not medical only, right? But there are many, many adult use only licensees. And within that, there's also social equity licensees. And within that, typically, as a concept, folks who are adversely affected by the war on drugs, um, including with convictions for drug possession, etc., were handed licenses as a sort of as a leg up to participate in this industry. It sounds like that could be problematic, but it also sounds like there's still not a path for these folks to register these products or register their entities simply because this isn't medicinal, it's adult use. Is the DEA going to come after all those folks for the unlicensed trafficking of Schedule 3 medicine? And the consumers who are 21 and older in every state who buy those things?
I can go first, in my opinion, on that. they aren't presently pursuing all of these people, and it's all, well, it was all Schedule One. They don't really have the resources. As I said before, there is no real appetite unless you have a tanker ship full of it, or you're involved in some kind of poly drug organization. Then it seems very unlikely to me. And certainly, like the DEA has limited resources, and I would certainly hope, right, that they would be focusing on more legitimate threats than that. And if everything gets moved to Schedule Three, additionally, because I mean, the sentencing guidelines are weaker on a criminal side, I don't think this is a big threat or a threat to the cannabis industry, prosecution. I do think that failing to comply with the regulatory side of it is a threat to your businesses. Maybe not your freedom, but if you lose your company because you didn't want to follow the rules, regardless of what we think of them, that's a separate matter entirely, and that's why it's key. And the most important thing is to show that you're doing everything you can to comply, and that's why working with companies like BCAGs is so essential, because it gives you the ability to have you're prepared. If they come, you're prepared. You can lay everything out, and you can document that you're following the rules the best you can. So if there are errors or small errors or mistakes or something in there, it's not it's not crushing, right? Maybe you have a small fine. They probably give you a pass. They're not out to crush those kinds of companies. So that's how I view this moving forward. But pass that to Mark or Jason.
I'll just add to this again.
Yeah.
I go to high altitude, and being a strategic planner, and one of the things you could look at is, for example, the drug czar, right? They have the Office of National Drug Control Policy. It's published under each administration, and it tells you the priorities of the different agencies on this. And as Eric mentioned, they don't have the resources, and on the prioritization of drugs that they can go after, this has got to be down at the bottom of the list. When, for example, we have 100,000 people die every year of fentanyl. That should be at the top of the list. So, if anybody wants to get a high altitude look at what you think the DEA may be doing, is take a look at that document and get an assessment of where you think their priorities lie and how they're going to fit in as the cannabis moves through the system. Like I said, I think it's, the train is moving in one direction, and you're probably going to see less involvement from DEA in this particular drug if it moves cannabis entirely to Schedule 3.
And let me just opine on this for one second as well. I think this is where companies, advocates, and whatnot need to reach out to their state legislators and create a framework. So Washington, D.C. kind of already set the model framework, because Washington, D.C. allows for customers/patients to be able to self-certify that they are a patient. Now, me personally, I'm a patient. I suffer from cerebral palsy, and I believe that all use is medical use, because regardless for what reason you're using cannabis for, there are many medical benefits that you receive just from consuming cannabis as a lifestyle choice. And so therefore I subscribe to the thought that all use is medical use regardless of whatever. But if states and municipalities allow businesses and allow customers and patients to be able to self-certify at the point of sale, that they are a patient and that they are consuming cannabis for a medical reason, I think that is really where the rubber meets the road and what really needs to happen. Because then at that point, every single market becomes a medical market. Every single business is able to experience the 280E deductions for tax deductible expenses. And that is really what needs to happen. And that is the main way of how we make medical cannabis great again, and which I happen to believe is part of the agenda of this administration.
Okay. Well, that was a good high note to end on. So I want to thank all of you guys for your time and your really interesting insight here. I think what we'll do is for every listener that wants to get in touch with these guys and get their assistance with the application or any other issues related to what is now kind of a sea change in the industry and the trend that we're going in, we will have everybody's contact information available at the end of this webinar. So thank you guys. I really appreciate your time. Thank you to all our listeners, and feel free to reach out with any questions to any of us.
Thank you, Irina.
Thank you
Thank
so
you.
much for your time.